Good day, sir. I am Mahid B. Angago from ACC1A, and I am going to discuss my five chosen subtopics, which are the stages of contract, form of contract, simulated contract, rules and interpretation of contract, and the vices of consent. First is the stages of contract. Conception or preparation or generation stage is the first stage of contract that involves preliminary negotiations and bargaining, discussion of terms and conditions with no arrival yet of a definite agreement. This stage ends at the moment of agreement of the parties. Perfection or birth stage is the second stage of contract when there is meeting of minds between the parties on a definite subject matter and valid cause. It is the moment when the parties come to agree on the terms of the contract. Termination or consummation stage is the last stage of the contract when the contract has been fulfilled, resulting in its accomplishments. It refers to the performance of the terms agreed. Now let's proceed to the form of contract. Contract shall be obligatory in whatever form they may have been entered into, provided all the essential requisites for their validity are present. However, when the law requires that a contract be in some form in order that it may be valid or enforceable, or that a contract be proved in a certain way, that requirement is absolute and indispensable. In such cases, the right of the parties to compel the other party to observe the formality required by law for mere convenience cannot be exercised. If the law requires a document or other special form, as in the acts of contract, for the convenience of the contracting parties, the contracting parties may compel each other to observe that form once the contract has been perfected. This right may be exercised simultaneously with the action upon the contract. And now let's proceed to the absolutely simulated contract versus relatively simulated contract. In absolute simulation, there is color of contract without any substance thereof, the parties not having any intention to be bound. The proper legal remedy is action for declaration of nullity. In relative simulation, the parties have an agreement which they conceal under the guise of another contract. The proper legal remedy is action for reformation of instrument. Now let's proceed to the rules on interpretation of contract. First is if the terms of a contract are clear and leave no doubt upon the intention of the contracting parties, the literal meaning shall be applied by the court. Second, if there is conflict between evident intention and words of contract, the intention of the parties shall prevail. Third is the interpretation of obscure words or stipulations in the contract shall not favor the party who caused the obscurity. The fourth is incidental. Circumstances of the gratuitous contract shall be interpreted with the least transmission of rights and interest. Fifth is the incidental. Circumstances of an onerous contract shall be interpreted with greatest reciprocity of interest. And the sixth one is in the case of doubt whether the contract is one of loan with mortgage or on a pacto de retro sale, it shall be interpreted as loan with equitable mortgage in favor of social justice. Next is if the doubt are cast upon the principal object of the contract is such a way that it cannot be known what may have been the intention or will of the parties, the contract is void. And next is in order to judge the intentions of the contracting parties, their contemporaneous and subsequent acts shall be principally considered. And next, however general the terms of the contract may be, they shall not be understood to comprehend things that are distinct and cases that are different from those upon which the parties intended to agree. And next is, if some stipulation of any contract should admit several meanings, it shall be understood as hearing that import which is most adequate to render in effectual. Next is the various stipulations of the contract shall be interpreted together, attributing to the doubtful ones that sense which may result from all of them taken jointly. Next, words which may have different signification shall be understood in that which is most in keeping with the nature and object of contract. Next, the usage of custom of the place shall be borne in mind in the interpretation of the ambiguities of a contract, and shall fill the omissions of the stipulations which are ordinarily established. And the last topic is the principles governing vices of consent. Violence or intimidation shall annul the obligation, although it may have been employed by the third person who did not take part in the contract. Failure to disclose facts when there is duty to reveal them, as when the parties are bound by confidential relations, constitutes fraud. The usual exaggeration in trade when the other party had an opportunity to know the facts are not in themselves fraudulent. A mere expression of an opinion does not signify fraud unless made by an expert and the other party has relied on the former's special knowledge.